Hey, federal employees, Shaun here. I want to talk about a question we're getting every single day. Can telework be a reasonable accommodation for me as a federal employee? And what should I know given everything that's happening right now? The short answer is yes, sometimes it can be an accommodation. The longer answer is it depends on your medical limitations, your job's essential functions, and whether telework effectively lets you do those functions without causing an undue hardship to the agency. Here's the big picture. Federal disability accommodation is governed by the Rehabilitation Act. The standard is whether you're a qualified employee with a disability who can perform the essential functions of your position with or without a reasonable accommodation. Telework can be one of those accommodations if it actually solves the barrier your disability creates. It's not about what's nice to have, it's about what's effective. So how do you show that? We'll start with your limitations, not the label. I have migraines as a label. I can't tolerate fluorescent lighting and commuting triggers episodes 3 days a week is a limitation. Then connect the dots. If I telework 3 days, I can control lighting and avoid commute triggers, and I can still hit my deadlines, attend secure VTCs, and be on core hours. That's the precise, credible bridge you want to build. So essential functions also matter. If your position requires in-person access to classified systems in a SCIF, telework may not be a feasible full-time thing, but a hybrid model or a different schedule might be. If your duties are computer-based and already performed remotely by others in your office, that's powerful evidence telework's effective. So is it the case if you've been working remotely for a long time and you've been effective? Past practice during the pandemic is relevant, but not decisive. Agencies can't ignore it, but they can analyze what worked and what didn't. The interactive process is key. You don't have to use magic words or a specific form to start it. You do need to explain the medical limitations and propose accommodations that address them. Agencies can request limited medical documentation to understand restrictions, not your entire medical history. Keep requests focused and professional. Offer alternatives, full-time telework, hybrid days, predictable scheduling, temporary trial periods, or equipment changes that make in-office days workable. Common myths to ditch: if I'm on a PIP or I had performance issues, I can't get an accommodation. Not true. Performance problems don't cancel your rights, so the agency can consider whether the accommodation will actually improve performance. Telework must be approved because someone else got it. Not necessarily. Comparators help, but your case rides on your functions and your limitations. If they deny telework, I'm done. No, not necessarily. Reassignment to a vacant equivalent position can be a reasonable accommodation if your current job can't be modified. Red flags I think deserve some attention: blanket no telework policies that ignore your specific job, denials that never analyze essential functions, demands for unlimited medical records, or managers who stop the interactive process instead of exploring alternatives. If you get a denial, ask for the specific reasons, what functions they think can't be done remotely, and what alternatives they did or didn't consider. You want to document everything. If you need a step-by-step game plan, we'll build a deep dive course for federal employees who want to request telework as a reasonable accommodation but can't afford a lawyer right now. So if you want that, it's $199. It walks through strategy, medical documentation, sample language, how to respond to common agency pushbacks. You can find it at fedlegalhelp.com/telework course. Some people want to know, should you talk to an attorney? Well, it varies, but if your medical limits are serious or evolving, if you're facing discipline while you're asking for an accommodation, the agency's slow walking or pressuring you to withdraw, or if you're considering reassignment. Also, if you think the denial is discriminatory or retaliatory, move fast. Federal EEO deadlines are short in most cases. If you're interested in seeing if we can help you can reach us at fedlegalhelp.com/firm or browse more resources at attorneysforfederalemployees.com. You serve the public, you deserve clear rules and a fair process. If telework is what lets you do your job safely and effectively, there very well might be a lawful path to ask for it, and we're here to help you navigate it. Thank you everybody for your support. Take care and have a good day.